Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. And today, ladies and gentlemen, is going to be marking the official end of the Federalist Papers series, coming off and capping it off with a recap of the 85 different papers. Now, obviously, we're not going to go through each paper individually for the recap, for the summation, but I do encourage you to go back if you didn't watch the series, and go ahead and go back and watch 1 through 85. I know they're on the longer end, about 15 to 20 minutes, but one of the frequent criticisms from the late and great Justice Antonin Scalia about the modern legal education system is that they don't teach the Federalist Papers. So understanding the Federalist Papers in addition to the anti-Federalist Papers will provide you a very advantageous, well-rounded understanding of the U.S. Constitution, and understanding the U.S. Constitution is, of course, necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over. I know it's been a minute since we've seen this format. Let's go ahead and jump on over to the presentation of our recap. Of course, if you need to pause, jot down any notes, anything like that, you're more than welcome to. Also, if you would like a download of this recap format or of this recap presentation, just let me know in the comments and I'll post a site to visit for all of the kind of summarized points that were mentioned in each of the Federalist Papers. Excellent. So let's go ahead and begin with Federalist Paper number 1, which was an introduction, where Hamilton, first and foremost, so he got the first word and the last word in the Federalist Papers, where he introduced exactly what the purpose, the intent, the scope of the Federalist Papers was going to be. This is where he mentions, so we have a new proposed government. Here are some of the objections we are already hearing and why a new government is necessary. After that, we have John Jay writing the second Federalist Paper, realistically focusing on foreign threats, where he acknowledges that the current Articles of the Confederation simply cannot adequately deal with the impending, with the threats that he viewed as impending and inevitable from foreign nations. Next, you have number 3, which is written by John Jay as well. America is too small. He was arguing here that the new government would provide an avenue for garnering respect for America, for the United States, for the 13 states, for the 13 colonies. He said if we continue on this path of division, on this path of division of independent state sovereignties, that foreign nations not only won't respect the United States and the Union, but also we would be an easy target. Number 4, again written by Mr. John Jay, America isn't respected. Continuing on what he was arguing in number 3. Number 5, also written by John Jay, he provides examples of the threats. Threats from Great Britain, threats from Ireland, threats from the Asian countries, so on. Number 6, Hamilton makes the case that divided, maintaining the individual state identities would be problematic, not only because of the intra-turmoil, the domestic fights and disputes, but also because there couldn't be a united front adequate enough to defend against foreign invasions, foreign attacks, foreign incursions. Number 7, written by Mr. Hamilton, could be attacked from the west, talking about Western territories. I think it was the Dutch. Don't quote me on that. But the Western territories, he was concerned about the American Indians, and then, of course, the settlers who were to the west. Number 8, discord between the states, from Mr. Hamilton, addressing what would inevitably come about 80 years later, despite the proposed new government that he advocated for being implemented, obeyed, and followed. So because of the individual state sovereignties being maintained through the Articles of the Confederation, he argued that the different states and their different interests would, of course, inevitably lead to a required army, to a required union government, or to a required union enforcement appendage that could keep the states in line. Number 9, same argument, but addressing the aspects or the advantageous aspects of the new government, how the supposed new government would come about preventing a civil war or the discord between the states, again written by Hamilton. Number 10, written by Hamilton, Union prevents factions, really honing in on this idea of divisive, divided, segmented state sovereignties will lead to internal conflict. Number 11, he switches the lens just slightly, focusing on how the union and unity between the states would improve international trade, that it would begin to garner respect, again written by Hamilton. Number 12, also written by Hamilton, the union would lead to an improved economy. He was articulating further on number 11 how the respect garnered on the global stage, yes, would benefit the states individually, but through unity, through having like a similar currency, economics, trade, commerce, so on and so forth would be easier, more convenient, and more fruitful to conduct. Number 13, again, Hamilton. I'll just let y'all know whenever we're switching from Hamilton, Jay, and Madison. By the way, those were the three authors of the Federalist Papers. You had Alexander Hamilton, who was probably the most in favor of the framers of a centralist government, meaning he didn't want the states, as we've kind of already addressed, he did not want the states to retain their sovereign identities. In fact, he overtly stated in one of his other pennings, not in the Federalist Papers, but in one of his other pennings, that he believed it was a bad idea for the 13 states to secede from the crown. So Hamilton was probably the most centralist. Then you have James Madison, who was looking to maintain federalism, federalism being the actual separation of governing authority. He wanted the states to remain sovereign. In fact, he went and practiced what he preached in 1798 when he drafted the Virginia Resolution of 1798, which overtly said the states are absolutely sovereign and they can absolutely nullify any sort of unconstitutional actions conducted by the federal government, conducted by the Union government, better said. And then you have John Jay, who I'm not sure why he was writing the papers, because the entire time he was insulting anyone who disagreed with him, but he was also quite the centralist advocate. So number 13, confederacies are confusing, again written by Hamilton, further honing in on this idea that if we have 3 or 4, specifically 3 or 4 is what he mentioned, 3 or 4 segmented areas that were confederations of these 13 states. So say 4 states went in this confederacy, so you have the Southeastern Confederacy. I went to that side. You have the Southeastern Confederacy, and then you have the Midwestern Confederacy, and then you have the Mideastern Confederacy, and then maybe the Northwest or the Northeast Confederacy. He said that would cause, or he argued that would cause, of course, disunion, but also confusion, disarray, would be an obfuscation of the currencies, making commerce, trade, and economics in general more difficult to conduct. That was his argument. Number 14, just want to secure the states. And no, he was not talking about securing to the states their sovereignty. Instead, he was prioritizing safety over liberty, which virtually every other founder, except maybe John Jay, disagreed. The main priority of the framers, as stated in the U.S. Declaration of Independence, that when in the course of human events, the ultimate goal, the ultimate purpose of government isn't to provide safety, it's merely to facilitate the citizens' exercise of their God-given rights, among those being life, liberty, which is contrary to safety, and the pursuit of property or happiness, depending on which draft you read. Number 15, states and citizens are separate. So he's talking about reserving or providing for the safety of the citizens, even at the expense of the states. Pretty contentious argument, pretty contentious paper that he wrote. In fact, we'll probably see here pretty soon, if you're following along in the Anti-Federalist Papers series, exactly how the Anti-Federalists addressed that and how they perceived it and how accurate they were in their prediction. So number 16, written by Hamilton, confederacies haven't worked, which was evidently not true. The primary argument against that was, of course, Patrick Henry's argument, where he said, well, the Articles of the Confederation were strong enough to beat the British Empire, so how could they possibly not be strong enough to maintain governance and peaceful times? So Hamilton was making the argument that confederacies haven't worked. He provided many historical examples, but all in all, they fell pretty flat. 17, the delegates are righteous by Hamilton. Hamilton, you see, routinely argued in the Federalist Papers that all of the individuals comprising the Union government, or the convention, the Philadelphia Convention, what we've been told was the Constitutional Convention, were righteous individuals. That the people in the U.S. Congress, the people in the U.S. Executive, and the people in the U.S. Judiciary would ultimately be the supposed best of the best from among us, because it's best to serve their interests, to be the best representative of the people, and then, of course, it's the best interest of the people to elect the best representative. That was his argument. Whether or not that's true, I'll leave that for you to decide. Number 18, historical examples of insufficiency. Pretty self-explanatory. 19, he references Germany. 20, he references the Netherlands. 21, another very contentious paper. The states must submit. So this is where Hamilton ultimately says the states need to comply or they're going to die. So he pretty well verbatim, both implicitly and explicitly said, if the states don't get along, don't get on the plan of the proposed government, the U.S. Constitution, then either the new confederation formed with the new government would eventually come and force submission upon the states that did not ratify the U.S. Constitution, or foreign nations would come around and exercise the subversive tactics, subversive ambitions of the newly formed Union government. So, must submit. The states must comply or they will die. One way or the other was Hamilton's threat. And of course, the Anti-Federalists quickly dispelled of that threat and pretty well laughed it out of their papers. 22. States want commerce regulated. This one was quite the pie-in-the-sky read, if you remember it, because he's doing exactly what he said the delegates and the U.S. representatives, the U.S. government officials in general would be doing. He was putting on the hat of the states and declaring on their behalf what would be best for them. It was not very well received. Hamilton in general was not very well received. 23. Must have an energetic government. Of course, this is completely antithetical to what the framers were looking to do. That's why they have so many kneecaps, so many obstacles for government action in general. Hamilton, of course, arguing to the opposite, advocated on behalf of having an energetic government, one that is very capable, one that is very intimately interwoven into your daily dealings. Not just at the state level, not just at the union level, but at the individual level. Hamilton, again, quite the centralist. Number 24, common defense equals executive. This is where he argues, obviously, the state militias are great for the state level, but what about foreign invasions? Well, foreign invasions would require and would be best repelled with a common tactic in mind, with a common order in mind. And it's much better, much more effective to have a single individual at that head to make unilateral decisions so that golden moment opportunities in times of war aren't hindered, aren't impaired by something like a council debating the best course of action. So even if your executive is completely inept at wartime, Hamilton argued that it would be better for him to make that unilateral decision rather than for weeks and months to occur where debate was taking place about the next best action. 25, practicality of the executive, further extending on number 24. 26, the legislative must have military. He's referring to Article 1, Section 8, Clause 13 or 14, where it directly gives the U.S. Congress a navy, to provide for and maintain a navy, and then, of course, to commission for a maximum of 2 years an army, actual boots, not just navy vessels. He had argued without the Union having a quasi-monopoly on militaristic ability, that the burden would unfairly shift upon the states most susceptible to invasion. So the coastal states would have to take up a much heavier burden than landlocked states. So in order to mitigate that unequal burden, Hamilton argued in favor of the U.S. Congress having militaristic ability, having militaristic power, so that way, tax collection, resource allocation, things of that nature are more evenly dispersed rather than the coastal states having to burden all of the cost, all of the training, all of the time, all of the land, all of the ports, so on and so forth. Number 27, more encroachment equals more engaged. Again, Hamilton making this, the delegates are going to be angels. The men we elect are going to be angels. That supposedly, if the federal government, if the union government were to encroach on the individual level, that the individuals would become more engaged and, of course, repel any sort of invasions or encroachments. In fact, in the latter papers, y'all may have remembered from number 85, 83, it was in the 80s, just recently we talked about it. He had said, thank goodness the state legislatures are going to be retained, because if the union government goes awry and becomes tyrannical, well, the citizens have the state legislators to step in, or the state legislatures to step in and prevent further encroachments. So thankfully, there are so many safeguards against federal encroachment. Obviously, that didn't play out, but the sad part is he was warned, and the Federalists were warned by the Anti-Federalists, specifically predicting the very tyrannies that we experience today. But of course, individuals like Hamilton knew, they just refused to implement that into their philosophies. Number 28, law doesn't always work. Hamilton, talking about pen on parchment, ink on parchment is not enforceable, which is why you have to have something like a military. The pen on parchment is great for principle, great for theory, not good for practicality, not good for maintenance and preservation. Number 29, standing armies are not allowed by Hamilton, written by Hamilton. Standing armies are not allowed. I would encourage you all to read number 29. Number 29 really hones in on Article 1, Section 8 and the extent that the federal government can maintain boots. Now, Article 1, Section 8 says the federal government can have and maintain a navy, but when you look in the dictionary from 1750, not Samuel Adams. Well, it may have been Samuel Adams. There's a 1750 dictionary that was almost guaranteed to have been the dictionary referenced by the founders. It was some 620,000 copies printed and sold, dispersed around the world. But in that dictionary, navy was defined not as the corpsmen, not as the seamen, not as the corps, but as naval vessels, as ships, and that was it. Which, when you take into consideration Federalist Papers like number 29 and the Anti-Federalist Papers and what George Washington said about standing armies, it's copacetic. It's succinct. It wouldn't make sense for the U.S. government to have a standing army via Article 1, Section 8 and the maintaining Navy clause, and then for virtually every founder to say, hey, standing armies are the number one opponent of liberty and freedom, which is exactly what Hamilton said in 29. Number 30, Hamilton argues that the government needs more money, and of course he references multiple examples where the Articles of the Confederation had good plans, good ideas, but not necessarily the resources or the funding to conduct them. So he makes the case for the U.S. having a wider array, a wider base from which to choose taxation upon, or to levy taxes, to wage taxes. 31, union can tax very few things. Both of those I would recommend y'all read. I would recommend taking the time not just to watch the lecture, but to read through it. If you'd like to watch the lecture, of course, I would encourage you to watch all of them. But as we go through here, I'll point you to some of the most important, some of the most consequential and significant papers that if you don't have the time to watch all of them, then going through them, or going through the ones that I specifically point out, will be greatly to your benefit. Like number 31, where he says the union can tax very, 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 very few things. Imposts, exposts, and excises. Very good information. Number 32, there is no consolidation of the states. Also very important, probably the most important. Again, coming from Hamilton. If Hamilton is saying it, you can guarantee the other centralist advocates like John Jay, maybe Oh, there's another individual, John Adams. That's who I'm thinking of. I don't know how his name could have slipped my mind, but if Hamilton is saying there is no consolidation of the states, then when the other founders say, hey, the Union, the US, is not a country, it's not a state, it's not a nation, that wasn't the minority opinion. That was the virtual universal understanding. Even if Hamilton is saying it, then it's probably the universal understanding. At least the consensus between the Federalists and the Anti-Federalists. Hamilton outright in number 32 says it is not a nation, it is not a state, it is not a country, it is a union with a capital U. And if you notice as you read through the Federalist Papers, he almost always capitalizes union when referring to the United States. To these United States, excuse me. Number 33, probably equally as important, tyranny is null. And he gives a really good description on exactly what tyranny is, on exactly what the rule of law. He doesn't explicitly, if I remember correctly, he doesn't explicitly say the rule of law, but the natural principles that are derived, that are inferred from what the rule of law is stated to be. So he talks about the simplicity, the necessary simplicity of laws, the conciseness, the brevity requirement of laws, so that the average individual does not have to depend upon a class of men like lawyers to interpret the law for them. Because the moment you do that, the laws will be interpreted to lengths that are unrecognizable, and then the government just has infinite interpreted, implied, in quotes, implied powers, which is absolutely not what the Articles of the Confederation formed or the United States Constitution formed. Number 34, another great Federalist paper. There are some times that Hamilton was agreeable. Sometimes he had his wits about him. Number 34, definitely one of those papers where he overtly states, well, declares that states have co-equal authority to the Union. That principle was put into practice by the father of the U.S. Constitution, James Madison, also co-author of the Federalist Papers, and the author of the U.S. Declaration of Independence in 1798 with the Virginia and Kentucky resolutions, where they nullified federal action. Very, very, very important principle, because the number one argument you will get is, well, the Civil War settled that. No, the Civil War proved what the Federalists stated in their papers, that whenever a government devolves to arms, that isn't the end of the government. It is a fruition, a completion of the actuality that your government had already fallen. And that's the only thing that was answered in 1860, in 1859 to 1865. That was the only question answered. There was nothing constitutional. There was nothing legally binding. There was nothing just. There was nothing right or wrong. It was merely moral arbitration, which the Federalists like Hamilton overtly said the Union government is not formed to do. That moral arbitration was imposed by arms, a total dissolution of government. In number 35, Hamilton addresses the uniformity or the application rule, the application or the uniform of law application determination for the Union. So instead of, or as a prerequisite for ratifying the U.S. Constitution, a key tenet, a key principle, it's both implied and explicitly stated in the U.S. Constitution, is that the states, whatever law the U.S. Congress implements, has to equally apply to all of the states involved. That it couldn't favor California, well, not California at the time, but it couldn't favor New York over New Jersey or Rhode Island or Connecticut, so on and so forth. 36, direct and indirect taxes from Hamilton. So direct taxes, something that the federal government can actually levy on imposts, exposts, and excises. It is exposts, if I remember correctly. Don't quote me on that. It's in Article 1, Section 8. Not Section 8. Or maybe it is Section 8. Well, it escapes me for now. But direct taxes being something individuals can't avoid. Indirect taxes being something individuals can avoid. So an indirect tax would be something like a sales tax because you don't have to purchase a certain item. A direct tax is something like an income tax. something like an occupation tax, where if you practice that occupation, you have to pay that tax. Now, of course, you can argue that all taxes are indirect because you don't have to be a member of the taxing authority, or you don't have to be subordinate to the taxing authority. But from Hamilton's perspective, there was these two classes, one that you can't avoid from things like not purchasing certain items that are taxed, and then the ones that you can't, such as a capitation tax. And if you remember from, I think it's Article 1, Section 10, capitation taxes are strictly forbidden, prohibited, overtly, and that was not amended by the 16th Amendment. 37, now we're switching over to Madison for a little while. As you can see, quite a few M's. So now we're switching to the father of the U.S. Constitution, James Madison. In 37, he argues conventions are tough. They're difficult to bring together, and they're even more difficult to bring some sort of consensus from. So don't be so lambasting of the individuals and the delegates who go there, who are at the Philadelphia Convention. Of course, I would argue to the contrary, because they're trying to form an entirely new government. So yes, harpoon them. It's meant to be a difficult job, because you're, without exaggeration, determining the affairs of other people that you probably would never know in your entire existence, in your entire life. So it's a heavy job. It's a difficult job. It's a tough job, but rightfully so. And it needs to come with the gravitas responsibility that is inherently part of that difficult job. Number 38, usually kings determine law. So he's saying, Madison is arguing, I understand we may not get the perfect exact government that we want from this convention, which is already contrary to what the framers had in mind. It didn't have to be perfect, it just had to be freedom-oriented. And this new proposed government, as very, very well predicted and prophesied by the Anti-Federalists in the 1780s, late 1780s, this proposed government was not liberty-oriented. It was, as Hamilton stated, safety-oriented, to secure or to make safe the citizens and the states. So Madison in number 38 is saying, get a grip. Be happy with what you're getting right now, because normally a king would be making these decisions. Yeah, well, Madison, I understand that position. I understand the be happy with what you get. But the point of the revolution was to make certain that we get as close as humanly possible to a perfect government, which takes time, which takes strict and strong criticism. So sure, you're right, it usually can be kings, or it usually is kings determining the law. But why, what was so immediate that we needed to rush and implement this new government when we knew for a fact it was not liberty-oriented? Number 39, one of the very important papers from the father of the U.S. Constitution. It was not, does not, and will not ever form a nation. He says that verbatim. It may seem like there are aspects that are from a national government, or that are of a national government. There are aspects that appear to be from a federal government. In total, in conclusion, it is not, excuse me a moment, the U.S. Constitution is not, again, from the pen of the father of the U.S. Constitution. He says, it does not form a nation, it does not form a country, it does not form a state. It forms a union. A union between co-equal, which Hamilton stated in 34, co-equal, independent, sovereign states. It does not form a nation. Number 40, is the convention legitimate? This is where Madison makes the concession. Look, I know the second to last paragraph in the Articles of the Confederation requires unanimous consent, unanimous agreement between all of the states to make any sort of amendments to it, let alone completely replace it. But listen, here are some of these dangers, here are some of these threats that we see are immediately impending, and because of that, if we weren't to recognize this convention as legitimate, we would ultimately be sacrificing what we believe to be the ultimate purpose of any government, which is to secure the citizens, to secure the people. So to not allow this convention would, in and of itself, though be breaking the Articles of the Confederation, would be a violation of the government's ultimate inherent purpose. Again, this argument not well received at all by the masses, because it's the same scare tactic that every tyrant has used. Even if Madison himself wasn't necessarily a tyrant or a dictator or had malicious intentions, it's the same argument that's always used for government overreach. Anytime the individual identity is to be sacrificed, it's for the sake of unprecedented times. For the sake of, well, we've never experienced this before, even if they have. That's always, always, always the argument used. Always the propaganda that is displayed. These are unprecedented times, so we must rush right now, and you must sacrifice everything. You have to give all of your liberty, all of your individuality. You have to give it all away to face what we believe to be an immediate threat. That's why the argument in number 40 by Mr. Madison fell flat, fell on deaf ears. 41, he goes into very solid detail about the powers being conferred directly to the Union government, and he says very specifically, the powers conferred are directly enumerated. Everything else is retained by the states. Everything else is retained by the states. Article 1 sections, it's in the first section of each of the branch developing articles, so Article 1, 2, and 3, and it's also restated in Articles, it's in Article 1, Section 8, 9, and 10, that there are very, very few things the states can't do, and then everything else not stated or not granted to the U.S. government is retained by the states. So Madison, again, the father of the U.S. Constitution, says there are no implied powers. There are no powers to be interpreted from the words that we've written down. Everything that we've written down are the only powers that are exercisable by the federal government. Every other power, new under the sun, old as dirt, doesn't matter. If we didn't give it to the federal government, it is retained by the states. If you don't like it, leave the Union. Number 42, he talks about consuls and commerce. Why the federal government should have a hand, why the federal government should be the monopoly on inviting in consuls and diplomats. It was to provide a unified front, a unified principle when making offerings, treaties, trade deals, so on. That it would become confusing and diluted if each of the states were to retain the powers of dealing with foreign diplomats and consuls. And he argues the reason commerce, why the federal government should have a hand in commerce, was a very similar argument to what Hamilton was making. Having a common currency, having common weights, so on, makes it so much more convenient. Now, I completely disagree with the position. Economically speaking, it's unsound. I mean, throughout all of history, it's never worked. But his position was the same as every other empire's position that is advocated for a fiat currency, a state-sponsored fiat currency. Having a common currency supposedly makes trade and commerce easier, more convenient, and therefore more appealable, more attractive to the merchant. Number 43, another one of those very important papers to read. Madison explicitly declares the U.S. Constitution forms a republican government, not a democracy, not a democratic republic, not a constitutional democratic republic or a republican democratic constitutional republic democratic. No, a republican form of government. And he provides a distinction between republican and democratic formats of government, as well as completely condemning the idea of democracy. In fact, I think it was Madison who had said the reason they formed a union of constitutional republics is because democracy, or rather than democracies, is because democracies are short-lived, and when they die very bloodily, very horrifically. Number 45, Madison makes the case for why the states should determine how the taxes are collected. So the federal government, like the states, can provide for a budget, but ultimately it's up to the more compartmentalized body politics to figure out how they're going to raise the revenue sufficient to fulfill or accommodate the burden or the budget burden. So the federal government can say, hey, we have this budget for the Navy. States, y'all need to pay the budget. Here's your portion. Here's your percentage of it. We're not going to tell you how to raise the funds, just that this is the number of funds that we need raised. If you want to levy a property tax, if you want to levy an income tax, if you want to levy a sales tax, that's for you to decide. We're going to leave that to you. Real quick, I just noticed we skipped over 44. It's actually a very important Federalist paper because number 44, Madison makes very clear what he was directly arguing in number 41, which is the necessary and proper clause does not give the U.S. Congress or the other two branches a carte blanche, depending on how you pronounce it, a carte blanche permission slip for the federal government to enact any sort of laws, any sort of actions that it so desires. The necessary and proper clause is preempted by the presumption that every act from the federal government will be in compliance to Article 6 of the U.S. Constitution, which is that every act and every law has to be made in pursuance of the U.S. Constitution. So it's only necessary and proper if, first and foremost, it is compliant with the U.S. Constitution. Even the U.S. Supreme Court has gotten that wrong, and we're going to be addressing that in our SCOTUS Blunders series here pretty soon. Another one of the very pivotal case precedents that modern lawyers, modern jurists, we have to say that with quotation marks around their names as well, because they're not actually lawyers and jurists. They're, as Antonin Scalia called them, purposivists. They apply the law as they believe it should be written rather than how it's actually written. But what Madison says so clearly in number 44 is necessary and proper does not mean necessary and proper according to the individual, according to the congressman, according to the president, or according to any number of the 9 justices on the bench, or any number of the justices sitting on the bench at the time. It is necessary and proper pursuant to the U.S. Constitution. Number 46. If, in fact, the federal government becomes tyrannical, here's where Madison makes it overtly clear. The states are co-equal to the federal government. That they have just as much say, if not more so, in determining the constitutionality of certain acts, actions, and laws from the federal government as the federal government itself. In number 46, another one of the most incredibly important to read. He says, when, frankly, the way he postured his paper, it was a when, not if, an inevitability. When the federal government goes tyrannical, the states have every ounce of permission from the framers and the authorities granted through the U.S. Constitution, and of course the powers retained by the states, to rise up both diplomatically and militaristically against the federal overreach, against the federal encroachments. And then he went on to practice what he preached with the Virginia and Kentucky resolutions. I think Madison drafted the Virginia resolutions of 1798, and then Jefferson wrote the Kentucky resolutions of 1798, if I remember correctly. Number 47, separation of powers. Madison talks about the necessity of having these 3 distinct branches and how they provide checks and balances against each other, thus prolonging the focus on maintaining and preserving liberty of the citizenry. 48, further explaining how the separation of powers is both beneficial and necessary, especially for a republican form of government. 49, people need remedy. So now he's discussing the modus operandi by which the citizens of the states can actually impose not just their liberty, but also the aspects of the U.S. Constitution that are designed to protect their liberty. How do they go about doing that? He provides multiple avenues. First, you go to the courts, which is more of a courtesy because the courts are always going to side with whoever writes their checks. You can't get the courts, then you nullify. If you can't get nullification, then you secede. Number 50, faults of people's appeal. What he argued here is fairly similar to the idea of the appealing principle, having the judicial hierarchy. If one court is already not applying the law as it's written, rather they're applying the law as they believe it should be written, appealing it to another court, whom will have magistrates of similar caliber, of similar schooling, you're going to get the same result. So why have the appeal? Later on, he'll argue, actually, it's have the process in place so that way it takes time for tyranny to completely overwhelm an individual. But that's what he argued in this paper. That if you have one court already not applying the law, having a higher tribunal to appeal to isn't really going to play to your favor at all. And then 51, kind of furthering the idea that he states in 50, 51, Madison discusses if men were angels. If only people would follow the rules, if only citizens would obey, well, not just the citizens, but more so the government officials, if only they would follow the rules, only if they would stay within the scope of their authorities, we wouldn't need a government. And he was directly addressing some of the critiques from the Anti-Federalists about the proposed Constitution and how it would inevitably facilitate tyrannical government. But he says, listen, we are trying to resolve the deficiencies of the current government, of course, without giving too much power to the government. And the only way that we can find thus far is, instead of trying to keep this government constricted while also giving it the powers necessary to answer these deficiencies, we're going to make it very difficult for them to conspire. We're going to make it very difficult for them to go outside the scope. Did they do a good job? Well, we know not even 10 years later, we got a pretty clear answer to that question, but that's what he's answering here. And then number 52 really articulates on that principle and puts it in a practical sense. Why the biennial seats? Why they designed the election cycles the way they did in the proposed Constitution. Number 53, Madison makes the same naive mistake that Hamilton made maliciously. So he just recognized earlier that men aren't angels. But then he makes the argument here in number 53 that the members who are appointed, congressmen, president, justices on the bench, are going to be talented, are going to be the best among us. Number 54, he explains why appointing members ought to be, how do you want to word it? Bifurcated, you could say. Bifurcated between the president and the Senate. Number 55, number 55. He discusses why the number of members, apportioning members, not appointing. Number 54 is apportioning members. That did seem off. So apportioning members, he's talking about congressional seats. He's talking about the consensus. Please pardon my mistake. Number 55, the number of members, he explains why the apportionment. He's explaining why it was, I think, 32,000 per House member. Number 56, he says, really, the bigger the number, so he's talking about the ratio of representative to populace, and he says the reason the bigger number doesn't necessarily provide for better representation is because the more delegates, the more representatives, the more, well, that's really the best term for it, best representative. The more representatives you have, the more diluted the debate becomes, because the more input, the more voices you have. So sure, you may have your individualized, specialized self-interest as a delegate in the convention or as a delegate in Congress, but he's one among 3,000 now. So there's a compromise that has to be made between not overinflating the House, but also not dismissing the interests of the citizens of the states. And that Madison admits in that paper. That's a very difficult matter to address. Number 57, regarding supposed oligarchy. So Madison's directly addressing a critique from the Anti-Federalists, saying, well, realistically, the checks and balances that we put in place would make it really difficult for an oligarchy to come about, for all three of the branches to conspire, and that's realistically what would be required, which is why they gave the House the purse, it's why they gave the president the sword, and it's why they gave the justices the gavel. Keep the tools separate from each other so that there's not a singular tyrant capable of wielding them all. And it would be really difficult, as per Madison's argument, to bring all of those and to congregate all of those tools into a single person's hands. Number 58, members will grow with the states, talking about enlarging the proportion. Not to inflate, not to overrepresent certain states, but to make sure the proportion remains constant, that every state is proportionately represented in the Congress. Number 59, Congress regulating elections, directing or provided by Hamilton. So he's arguing for the federal government's involvement in how the elections are going to be conducted. Now, of course, the U.S. Constitution says that the states are going to retain how their elections will take place. If I remember correctly, it establishes when an election or when the election day will take place and the term lengths for each of the offices, but ultimately how the election is going to be counted, how the election is going to take place, where the voting booths, if there's going to be a voting booth, if it's going to be paper or digital, all of that is left to the states. Hamilton argues against that. He argues in favor of centralizing and formalizing the election procedure. 60, he discusses the direct election of Congress, why it's important, but also very dangerous. He explains the difference between the House of Representatives and the Senate, that the Senate is to represent the state's best interest, and the House of Representatives is to represent the citizens' best interest. Sometimes those two, just like with the states and the Union, sometimes those two conflict. You have the citizens who do know what their best interest is, what their best interests are, but maybe the state is incapable of providing for that. But then the state, through the Senate, is able to prevent a tyranny of the majority, to prevent that core tenet of democracy from rising and gaining foundation. Another reason why the founders almost universally condemn the idea of democracy. Sure, the state is important to protect the citizenry, but the citizenry can be just as dangerous to the state. And one of the founders notoriously had said, whenever the government fears the citizens, that's when you have freedom. Whenever the citizens fear the government, that's when you have tyranny. It's incredibly important to maintain a perfect balance between the relationship, or a perfect balance in the relationship between the state and the citizen. Because if you have citizens who hate the state gets dissolved, which of course can put at jeopardy the citizen's safety. If you have a state that hates the citizenry, and of course you have enslavement. And inevitably you have revolution, which all in all brings about chaos, bloodshed, and tragedy. 61, the election process is honest, again from Hamilton. Really kind of making a naive statement, a naive argument, but that was his argument nonetheless, that they did the best they could to establish an election system that was, of course, representative of the states, of the citizens, but also equitable, was equal in representation, and was as equally accessible as possible. Next. So now Madison in 62 specifically outlines the Senate, the purpose of the Senate, which was, first and foremost, to represent the states, which is why the states could call back their senators at any time for any reason, because the senator was to serve the interest of the state at the federal level. 63, again from Madison, the operations of the Senate, how the Senate was going to be conducted, the elections for the Senate, senator qualifications, so on, so forth, discussing how the Senate is going to be involved as he used an exact term. The House of Representatives had the purse, the Senate kind of had the checkbook, you could say. So the House of Representatives had direct access to the coin purse, but the Senate had to write permission for implementing its policies in the sake or on behalf of the states. 64, written by John Jay, Senate Can't Be Corrupted. I would encourage y'all to read that paper, not because it has valuable information, but rather to show just how it was incompetence or malevolence that John Jay had. It really is quite comical how absurd and how caricatured he made himself. Because it was a total devotion to this idea that union government officials were going to be the perfect and angelic men. We all know that's not the case, but that's what John Jay believed. 65, Court of Impeachment from Hamilton. Hamilton explains why the Senate ought to be the court of impeachment rather than the U.S. Supreme Court. 66, Hamilton argues for trust in the Senate, not just in trials of impeachment, but also in being a check against the executive, a check against the House of Representatives, and a check against the U.S. Supreme Court. 67, Hamilton explains the executive, why he ought to be able to, or why he's the chief diplomat, why he's to be the head of the military, the commander-in-chief, why he's going to have the powers that he has, and that hopefully they designed the executive well enough to not inevitably become a king. Now, Hamilton, in his other pennings, made it clear that he wanted a king, which is why he pushed so fervently for Washington's election, because he believed that Washington was the only man who could effectively and affectionately prove to the people that having a king in the executive would be a good thing. 68, again from Hamilton, how the executive is elected. Fairly self-explanatory. No policy changes there except for the 2-term limit, but realistically that tradition was already steadily set in place. 69, the character of the executive. This is where Hamilton makes it overtly clear that he wanted a king. I would strongly encourage you all to read number 69. Number 70 from Hamilton, an energetic government is good. Completely antithetical to what virtually every other founder, except maybe if you consider John Adams and John Jay, virtually every other founder disagreed with. An energetic government is not good, because an energetic government, well, what Hamilton argued was an energetic government is good because it provides for the protection of the citizenry, provides for safety, it provides for action. What virtually every other founder believed was an energetic government is an involved government, and an involved government is a restrictive government, is a tyrannical government, is a slaving government. So I would encourage y'all to read number 70 as well. 71, tenure of the executive. Hamilton provides exactly why it's so important that the executive serve the terms that he does in the way that he does. Hamilton, if I remember correctly, made the argument that if it's shorter than 4 years, and he brings up multiple examples, like the governors of the different states, but he says if it's shorter than 4 years, then obviously the executive won't have enough time to implement his plan. If it's longer than that, then he gets closer to being a king. But if you do it every 4 years, every 3 to 4 years, then of course that provides him the length to enact his plan, and thus the amount of time requisite for citizens to truly criticize the policies and implementations that the executive had in mind. Number 72, re-electing an executive. I misspelt that. We'll just leave it. Re-electing an executive from Hamilton. So this works in addition to 71, discussing why the citizenry would vote to elect or to re-elect an executive, and that the tenure plays directly into that, being an honest and authentic and representative vote. Number 73, President and the veto from Hamilton. He explains why it's so important that the president have another check against the other two branches, against the Congress in particular. But why it was so important that the president not only have the sword to wield, but also a diplomatic veto. 74, the golden opportunity from Hamilton. The golden opportunity referred specifically to turmoil, and that with the president being unilateral in his diplomatic affairs, is able to best exploit, without the intermediary debate and conversations of something like a council, to take advantage of those golden opportunities. Where when you're in the middle of a fight, in the middle of a conflict, and you have a singular individual who can, at a moment's notice, call for conversation, call for conference, and discuss singularly with another leader, that would take far more bureaucratic time if there were to be a council. So instead of having that golden opportunity, instead of having that genuine, authentic moment, it would have to be played, or it would have to be scripted, and it would have to be thought out, and it would have to come off as artificial, which obviously would not in any way be as beneficial or maybe as fruitful as the golden opportunity. 75, making treaties. In Hamilton, he's explaining why the states ought to be prohibited from making treaties, as well as why the Union government ought to monopolize the authority of making treaties. 76, regarding appointments. There we go. Definitely did not discuss that in those earlier papers that I mistook it for. So number 76, regarding appointments, he's talking about the president. The president making certain appointments to his cabinet, making certain appointments to the courts, and how the Senate provides an effective check on exactly who these talented individuals would be, so as to prevent this oligarchic or despotic government arising from maybe personal relationships that the executive would have with his appointees. Number 77, Hamilton discusses the checks on the president, whether that be from the Senate, whether that be from the U.S. Supreme Court, whether that be from the House of Congress, in terms of his commission of his pay. That the president effectively, he really did focus quite a bit of time on this, because it was one of the larger critiques from the Anti-Federalists. They pointed out very frequently, very routinely, that you are making a king with the executive. Since he is wielding the sword, he is ultimately the one with the definitive authority, the definitive power, and that you can set limits on him, but that's just, like you said, Hamilton, ink on parchment. He has the firepower. Even Washington fell prey to that during the Whiskey Rebellion in 1795, when he forced a group of 500 Pennsylvanians. Washington deployed 10,000 troops to capture 500 Pennsylvanians who refused to pay an abusive and unrepresentative tax. And we know for a fact that Washington knew it was wrong, because he pardoned every single person involved. Not even Washington could resist the tyranny that the Anti-Federalists had predicted. So the arguments made here in 77 by Hamilton fell on flat ears. 78, again by Hamilton, titled The Judiciary Department. Please go and read this one. This one is so incredibly important. Because what do you hear all the time from lawyers, jurists, judges, and justices? We hear the courts are final. We hear, if you don't like what the court says, appeal it. If you don't like what that court says, appeal it. If you don't like what that court says, appeal it to the U.S. Supreme Court. What Hamilton makes overtly clear in the Judiciary Department, or in number 78, titled The Judiciary Department, is that's not the case. That's not what even Hamilton, the centralist framer, believed the judiciary to be. It is not to be the moral arbiter. He says that verbatim. They are not to discuss right and wrong. They are not to discuss or consider the contemporary needs of the society. They are to be the least popular, the least favored, the most hated body of the entire government, because their sole job is to apply the law brutally, candidly, and directly. They do not have implied powers. They do not have judicial review. They do not get to determine the extent of their own authority, because if they do, then they have an infinite amount of authority. And even Hamilton recognized that. And even Hamilton, even in his beguiling writings, admitted that. that if you allow the judiciary to be the ultimate authority in determining what is and what isn't constitutional, then there's no need for Article 6 in the U.S. Constitution. And he says that verbatim in 78, so please go and read 78. 79, Hamilton discusses why the justices ought to have the pension plans that they do, or you can call them pension plans, you can call them commissions, you can call them salaries. But he explains how it best, or how it directly contributes to their independence, to their objective opinings and opinions. 80, powers of the judiciary. This one's another important one. 78 is definitely more explicit about exactly the extent of the judiciary, but 80 is pretty good as well. Because I think it was 80, it's 78 or 80, where Hamilton said the judiciary is not the supreme arbiter of what is and what isn't constitutional. The legislature is not the supreme arbiter of what is or isn't constitutional. He says, in fact, what I mean to say is that the will of the people is supreme to both. The judiciary, the legislative, the executive are all servants of the citizens, not vice versa. And that's what he really explains in 80. 81, appellate jurisdiction. Hamilton, he's describing, of course, the higher tribunals as well as the final appellate court, which is the U.S. Supreme Court, and why it's so important to keep that appellate jurisdiction intact rather than providing a general jurisdiction to any and all cases. 82, another fairly important one, the powers between state and federal court, again by Hamilton. This is where he explains that, hey, the federal courts, of course, are going to rule on very specific matters, but that's only in the purview of the U.S. Constitution. The states ultimately determine what is and what isn't compliant to their state constitutions. The federal government does not get to nullify, the federal courts do not get to nullify state laws. But state laws can absolutely nullify federal action. And again, he said that earlier in, it was 39 or 40, the one titled Co-Equal. The states are co-equal in power. 83, Hamilton argues that jury trials are unnecessary, again, because the U.S. Supreme Court is the appellate jurisdiction. Jury trials are to determine fact. The Supreme Court is not supposed to be determining fact. It's supposed to be determining whether the laws were applied correctly to the collected facts. So you wouldn't need a jury trial because the jury determines the facts, not the law. 84, Bill of Rights is redundant. Now this one's very important to read because it'll turn your stomach and it'll boil your blood, and will very quickly show you why Hamilton cannot be hated enough. Despite us having a Bill of Rights, despite us having Articles 1 through 10 of the Bill of Rights, and they were referred as articles, they were not amendments, because as Thomas Jefferson said, they were prerequisites for him to even consider ratifying the U.S. Constitution or advocating on its behalf. The Bill of Rights was a prerequisite. It was not a postscript adjustment of the U.S. Constitution. They were required inclusions. So they were not amendments. They were articles. Articles 1 through 10. And if you read the preamble of the Bill of Rights, it actually labels them. It calls them articles. Anyway, Hamilton argued in number 84 that having a Bill of Rights was redundant because all of these rights were inferred or implied in the preceding 7 articles. And then, of course, number 85, where he ties everything up in a bow, getting the final word, provides his concluding remarks that he feels he sufficiently addressed all of the critiques and provided for all of the concerns that those might have, and hopefully, or he hoped, he had successfully captured the minds of the citizenry and convinced them in favor of ratifying the U.S. Constitution. Excellent. So congratulations. You've made it all the way through the Federalist Papers series. I hope you enjoyed it. If you have any questions at all about what was said in any of the Federalist Papers, go ahead and post them down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare, kind of like the lawfare that Hamilton was outlining in 78, that will be waged against you, your loved ones, or your hard-earned property. Equally, if there's a legal topic you'd like me to cover in a future lecture, go ahead and post that in the comments as well. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.